Hello, good morning, students. Please subscribe the channel, drop a like, share, and comment. This is Shree Vishnu Art Press Publications, exercise number 9 and 10 on the speed of 90 words per minute. Start. Having considered the aforesaid submissions raised, what we find is that so far as the issue relating to the Armed Forces Tribunal is concerned, the same was answered vis-a-vis the exercise of authority by the High Court under Article 226 of the Constitution of India, whereas in the present case the exercise of authority by a learned single judge in a company petition is in the discharge of statutory powers conferred under the provisions of the Companies Act 1956. Thus, this is not a case arising out of writ petition under Article 226 of the Constitution of India. Nonetheless, the issue is that the power which is being exercised by the learned company judge is a judge of the High Court and not of any inferior tribunal. Consequently, to that extent, we are of the opinion that once the power is being exercised by a learned single judge of the High Court in exercise of the authority conferred under the Companies Act 1956 in a company petition of 2013, an order passed therein cannot be subjected to appeal before a tribunal created under the 2013 Act. Even otherwise, the High Court as a supervisory jurisdiction under Article 227 of the Constitution of India, applying the principles thereof, the question of conferring the authority of appeal on a subordinate tribunal would be contrary to this constitutional scheme. The enforcement of Section 303 with effect from 15/12/2016 would not repeal the right or abrogate the right of a person to file an appeal against the order of a learned single judge in a company petition for which this court continues to have jurisdiction to decide the matter as indicated above, and in the present context, keeping in view the impact of the legal provisions pointed out herein above. The Company Appellate Tribunal has not been conferred with any such authority specifically as an alternative granting a right of appeal as against an order of a learned single judge passed in a company petition as is presently involved. In the absence of any such specific conferment of power on the Company Appellate Tribunal, the argument of Shree that the powers statutorily granted under Section 483 of the Companies Act would stand impliedly revealed cannot be repealed. The doctrine of implied repeal therefore will have no application in view of the aforesaid background of the legislation, as no such express intention can be gathered from the same. There is yet another reason for holding that the right of appeal is available to the appellant, and that is based on the principles that have been deduced, as discussed in the latest case of Messrs. Videocon International Limited versus SEBI 2015 4 SCC 33, where a right of appeal has been understood to be a substantive right and not a mere procedural right, so as to affect its applicability upon any amendment, more so when the list in the present case had been instituted earlier. On the other hand, Sri Tarun Verma, the learned counsel for the Oriental Bank of Commerce, submitted that the petitioners have an efficacious remedy of filing an application under Section 17(1) of the Act before the Debts Recovery Tribunal. In support of his submission, the learned counsel has placed reliance upon a decision of the Supreme Court in United Bank of India versus Satyavati Tandon and others, 2010 8 SCC 110. It was urged that after the declaration of the account of the borrower as NPA, the bank has already filed a suit before the tribunal for recovery of its amount, and that the tribunal has also issued an interim order restraining the borrower from alienating the properties, including the properties which is sought to be released through the present writ petition. The learned counsel contended that the appropriate remedy for the petitioner is to move an appropriate application before the Debts Recovery Tribunal, which would be considered, and appropriate orders would be passed by the tribunal. The learned counsel contended that consequently it was not a fit case for the writ court to entertain such petitions. The learned counsel submitted that the concurrence given by the Oriental Bank of Commerce for release of the property of petitioner number 1 was subject to fulfillment of certain terms and conditions at the time when the account of the borrower was standard and regular, but during the consideration of the matter, the borrower did not maintain financial discipline and the account of the borrower became NPA. As such, in the changed circumstances, the bank was not bound to honor the concurrence, since the conditions were not fulfilled by the petitioners. The learned counsel submitted that the borrower has failed to maintain the financial discipline and have made no effort to regularize the account, and consequently the request for substitution of the mortgaged properties could not be acceded to. The learned counsel further submitted that the account of the borrower was declared NPA as per the Reserve Bank of India guidelines, and since the borrower did not make any effort to regularize its accounts, proceedings under the Act was initiated. The learned counsel contended that a valid notice under Section 13(2) of the Act has been issued, and the objection of the borrowers and other guarantors were considered, and rejected under Section 13(3)(a) of the Act, and only thereafter a notice under Section 13(4) of the Act was issued, and now an application for recovery of the amount has been filed under Section 19 of the Recovery of Debts Due to Banks and Financial Institutions Act 1993. The learned counsel submitted that the plea of the petitioners that the respondent's bank had wrongly declared the account of the borrower as NPA is misconceived, inasmuch as such plea could not be raised for the first time in a writ jurisdiction, as the said plea was never raised before the bank nor was raised in their objection filed under Section 13(3)(a) of the Act.